Lane, I'm gonna disappear in a half hour to go do another meeting, and then I'll be back.
Okay, well, that's you and Susan. So, 'cause Susan's on the same double book schedule as you. Okay, let's go ahead. We'll start with the draft. We'll run through the draft that is dated October 12, the one that was with the meeting materials for this meeting. And then Lorianne, I'll ask you to keep us in mind, keep your remaining questions in mind as we go through, so we can kind of bounce back and forth between the draft and those. Then we'll go back to the questions and make sure that we've covered those in case we missed anything. All right, so Lorianne, what do you want to tell us about section 2?
Okay, so section 2, I didn't make any real substantive changes to this from the last version that you all saw. What I did do is try to clarify an issue that John Dranius pointed out in our last meeting about subsection 5 and the lead-in not working with talking about, so previously it had read that for the purposes of this section, an issue in a probate proceeding is contested if it is, and then it had like a proceeding for declaratory judgment or a petition to remove. So those two things didn't really work with the lead-in. So I changed it to it's an issue in a probate proceeding is contested if it is or arises from, and then went through and changed it to a petition or motion for declaratory judgment, a petition to remove, so I took out the proceeding and replaced that with a petition or motion. I think that fixes it, but does anybody have an objection to that change?
John, what do you think?
I think you're grammatically good now.
Yeah.
Okay, so the next section is section 3. This is language that the group provided to me. So
this is Jennifer. Sorry to interrupt. I had some more things on section 2, just really small things. I don't know if you want to wait or.
Oh, no, let's do it.
Okay, so in the section 4, C. Let's see here. I'm sorry. Subsection use just number 4. For the purposes of applying the ORCP. It means any party asserting a claim for relief, whether by way of petition or motion. Another way that can arise is by objection. And so Heather and I kind of looked at this yesterday, and Heather suggested adding after petition or motion the words, I'm sorry, means any party against whom the claim is asserted or who objects to the claim for relief, or if you add in after defendant means any party against whom the claim is asserted or who objects to the claim for relief, or then that should address that issue of the claim being raised by objection.
Okay, so take us through that again. I get this. I get the idea, and maybe we'll just leave it to Lorianne to style that. But yeah, say it again.
Okay, so it would, where it says defendant with the funny little arrows on it, it means any party against whom the claim is asserted, or, and we would insert the words who objects to the claim for relief, or, and then just continue with the rest of that.
Sorry, is that correct though? Because I thought
if you're objecting, you're a plaintiff, aren't you?
Yeah, I thought that for the purposes of applying ORCP, that the person objecting is in the plaintiff's shoes, and the person defending the petition or motion would be in the defendant's shoes.
But then you also have a person who has filed the motion. They're clearly the plaintiff, and then somebody objects to it.
No, I guess I see an objection as being an initial pleading or an initial filing.
Well, if you have a motion or petition, isn't that the initial filing?
I think Jennifer's right if it's an objection to a final account.
Yeah. But is the person objecting to the final account on their objection? Are they the defendant?
No, they'd be the plaintiff.
Yeah.
Yeah. Yeah, because they'd have.
Heather, you're muted.
Sorry. So I'm concerned about burden of proof. Like, whose burden is it to show that the accounting is true and complete? It's the person filing the accounting, not the objector. The filer has to prove that the accounting is appropriate. They go first in hearings, and then the objector is the person who shows that they're not accurate. I've never been in a hearing where the burden to show that it's not accurate rests on the objector.
Well, there's the ORCP, that doesn't govern burden.
Well, I think that there's a lot of stuff in the ORCPs that govern things like the order of presentation of cases in court. I mean, you're talking to a non-litigator who goes to litigation a lot, but I'm not a litigator. So we talked to Brooks and Matt about this section yesterday because we were puzzling it. What is the objector? How do we identify what the status of the objector is? So let's look.
Well,
Judge Cobb?
so another option would be, I just raised this issue. We can't leave out objection. It needs to be addressed here, and maybe we let the litigators figure that out.
Well, we're smart. Okay, you file, the personal representative files the final account. Now we have a beneficiary filing an objection. Who is what in that person? Who's got the burden in that case? And I don't know if I want burden to necessarily drive what's going on here. All we're doing here is aligning references to the parties in the ORCP to these various weird things in a probate proceeding.
So what if we look at one of the ORCPs that we're saying applies in these situations and talk through, in the ORCPs, it refers to plaintiff and defendant. And
Right.
so what we're trying to do is clarify for a contested probate proceeding or issue in a probate proceeding, which party is the plaintiff or the defendant. So the first ORCP that we're saying applies to contested issues in probate proceedings is ORCP 9, which is dealing with service and filing of pleadings and other documents. I am trying to find one that would be a good. Of course, no, I can't. That doesn't have plaintiff in it, so find one that has plaintiff. Why don't, I think it might be, so the Matts and Brooks were really the ones. Is Matt Strumpf on the phone? Was he?
No, it's Matt Whitman.
Well, the two of them, Matt Whitman and Matt.
I don't see either of the Matts.
Okay.
Judge Cobb,
Yes,
what do you
ma'am.
think?
This may be oversimplistic, but if the issue is you want to include objection in here, why isn't that, would the solution be petition, comma, motion, comma, or objection?
Well, that's
Well, and
if we want the objector to be the plaintiff.
Well, what's the practice? If you file an objection, don't you have the burden to
No.
establish
No.
your objection?
No, not in an estate. I mean, you've got to have the basis of your objection, but
Right.
we've addressed it later on. But then the burden, if it's an objection to an accounting, the burden of proof is always on the fiduciary.
It's the proponent of the motion or petition who is the plaintiff.
But it's the objection that triggers the application of ORCP. I think that's what we're getting hung up on.
Right.
So you have somebody files a petition in probate, and we're saying in general, the general rule is that ORCP doesn't apply.
Right.
But then an objection is filed. So at that point, then ORCP applies. And so that triggers the rules of ORCP. So is that trigger, does that make the objector the petitioner? And
No. Even though it triggers the application of the ORCPs, it doesn't make the objector the plaintiff. It just converts the proceeding. Because if you're the plaintiff, I mean, the fiduciary has already requested approval of the accounting. So if there's an objection to that, that's the trigger that converts the application of the ORCPs. But at that point, it doesn't reverse the roles of the parties. You still have the fiduciary who's the proponent of the requesting the claim for relief. And whenever you request a claim for the relief, you're automatically a plaintiff. That's a plaintiff, right? I'm saying that because I'm not a litigator, but that's my experience.
Maybe, and Heather, I think that's, as you say that, and I think that's right. Maybe a better way to do it would just be another sentence in 4 that says, in the case of an objection to a petition or motion filed by the personal, filed by the personal representative, the personal representative is the plaintiff, and the person filing the objection is the defendant. Something to that effect. Because an objection would only be filed against a personal representative, right? Would you ever have a personal representative filing an objection? I don't think so.
You might, because any interested person can file. Like, I could represent AIR and petition the court to remove the personal representative. At that point, I'm the petitioner. I'm requesting relief.
Yeah, but you don't. The PR doesn't need to file an objection to that. They just respond to your motion.
Yeah. So could the additional language be something like indicating that we're not intending to switch the burden of proof by these definitions?
Yes, I think that might be the solution, because the lead into this language is for the purpose of applying the ORCP. That's all we care about.
Yeah.
And then you could simply add the objection language to clarify, but simply state that it doesn't change the burden of proof. So whoever everybody decides is the burden of proof, because it's not that unusual in hearings that there's a huge final account and there's some objection. And if the personal representative's attorney doesn't understand exactly what the objection is, he talks to the objector and says, do I have to go through the entire freaking annual account or final account? And they go, no, we want to know about X, Y, and Z. And then they come in and establish that on the record at the very beginning so that, we don't have to start from the first allegation of a final account. That's what I've commonly seen.
So, okay, let's go back.
What if we, sorry, go ahead, Lane.
No, Lori, go ahead. I just said, let's get back. Sounds like you're getting back.
So what if we change the wording to, for the purpose of applying the ORCP to a contested issue in a probate proceeding, plaintiff means any party asserting a claim for relief, whether by way of petition or motion, and defendant means any party objecting to the petition or motion, or party against whom the claim is asserted. Because I think what I'm getting from the discussion is that the party objecting is the defendant, right? And the purpose of this is really to clarify that when you're looking at the ORCP and it says the plaintiff has to do something, you know which party that's in the probate proceeding is that person. So is it going to always be the person who's objecting that is always the defendant?
Let's do this. Let's go ahead and and do what you just suggested, because I think that at least captures the essence of what we want to do. And then between now and next week, let's everybody just kind of peruse some of those ORCPs and make sure that works.
All right, it's gonna be, I mean, I'll clean up the wordsmithing. a little.
Yeah. So I guess we're agreeing, I think, at least, subject to further consideration, that a party filing an objection will be considered a defendant for the purpose of the ORCP.
Yeah.
And Lorianne, how do you feel about adding language that says that this doesn't affect the burden of proof or the burden of going forward with evidence? Are you okay with adding something to that effect?
I'll have to look into it.
Yeah.
I'm not sure it
You don't
really,
usually say what a statute isn't doing.
yeah, I'm not sure it really fits.
Right.
Because it's just the ORCP,
Right.
not talking about burdens of proof.
Yeah, for style issues, there's lots of things this language isn't doing, and we're not saying all of those things that it doesn't do.
Another option would be to address the burden of proof in the part of the statute about the objection.
Or we leave it to the court to work. I don't know. Judge Cobb, is burden of proof an issue?
Well, I mean, when you don't have judges that are terribly familiar with the probate code, I think it could cause confusion if the attorneys are starting to argue that issue, which is kind of just a sideshow. And don't we want to clarify just so it's not on the table for somebody to argue about? And God forbid it would be a pro se person who wants to represent themselves.
Yeah, they're on their own. That's almost a different section, it seems to me. And I don't think we can tuck it into. It's certainly not into sub 4. And I guess, do you think it's a real issue, but is it one that we really can clarify with statutory language? I mean, it seems like there are so many different shades of that that it would be hard to draft language.
Can I ask what establishes the burden of proof in a probate proceeding right now?
Great question.
That's right.
I was just looking at some of the issues with burden of proof and what you have a right to do. And for example, in ORCP 47, which is summary judgment, we used to have a lot of language that would say plaintiff and defendant. But the way that ORCP 47 is drafted, it just says a party against whom a claim is asserted.
Mm-hmm.
They seek to obtain a declaratory judgment or summary judgment. So that doesn't seem to matter, but I don't know where the burden of proof lies. I always think the burden of proof lies on the proponent, but
Yeah.
maybe I'm.
No, I think that's true.
Well, and the proponent is in an estate is the fiduciary. They, it's always the fiduciary's responsibility to move this forward, to administer the estate, to report, all the statutory basis, and they always have the burden of proof.
So you're saying an objection isn't like an affirmative defense?
I don't think so.
Isn't
All right, I'm gonna do some research on this and see if I can find a place to address the issue. I don't think that section 2 is really the best.
Yeah, I agree.
Really talking about application of OCP, but we are also talking about application of the Oregon Evidence Code. So maybe I can loop it in somewhere there, but I'm gonna do some research.
Okay.
And at our next meeting, I'll send it off to Sandy to circulate.
All right, Jennifer, any other minor issue with section 2?
Yes, just one. When they're making, when they're making the list of the all the various proceedings, do we want to include elective share? Because that came up in an estate I had recently where somebody filed a motion about an elective share.
Hmm.
Is that not, you don't think that's covered by big 5A, big C?
Well, it's not relief against a person. It's a claim to a statutory right.
Yeah.
I don't think it hurts to call it out.
Yeah, probably not.
Does anybody have an objection to calling that specific thing out? All right.
Well, then, I hate to go down that road, but what about a motion for support?
That's a great idea because that comes up.
Yeah. That just, thinking about the elective share made me think about that support. What is that in chapter, was it 113 or 114? 13, I think.
Well, and
Just wanted to,
similar to that is the right to occupy the residence for 1 year, the spouse's right to occupy the residence for 1 year.
I mean, do you want to make that a contested issue in the probate? Is it contested if nobody objects to it? Like,
Oh,
you know, if they file a claim for that, but everybody in the proceeding is in agreement that, yeah, we should be providing some support for the kids and the spouse during the pendency of the proceeding, then is it contested?
This is Ken Sherman. I'm just looking at 5AG. Any other petition, motion, or show cause order determined by a court to be a contested issue. Why wouldn't that cover all of these things that you're talking about?
And that would be a good point. That, you know, if a spouse files a claim for or petitions for
support, yeah.
care or support, and nobody objects to that, then the court could say, I mean, or if somebody objects to it, then the court could say this is a contested issue and you need to, the rules of civil procedure apply. Yeah.
Yeah, I think that works. And then the lawyer could ask the court to determine that it's a contested proceeding, or maybe that's already done. I don't know.
Yeah, that's probably, I like that, Ken. I guess my concern about trying to create the laundry list is that we're going to miss something, and maybe we just trust the court's discretion to identify when they've moved into a contested issue. That works for me.
Would it work to have a comment to the legislation here?
Yeah, Susan, are you still with them? See, I'm looking at the draft and on the screen. Sandy, let's ask Susan to make add that as a comment.
Okay.
That this is not an exclusive list of things, and that anything that creates controversy or contest should be court should consider treating as a contested issue.
Okay. I'll make sure she gets that.
Okay.
And that's all I had, Lane.
All right. Thanks, Jennifer. Lorianne, you're going to take us to section 3.
Yeah. Yeah, I'm just making a note for myself so I don't do something different. Okay, so section 3 is language that was provided to me by the group way back at the beginning of this process, and we haven't looked at it yet. So what it says is that the court, in its sole discretion, may require that a hearing be held on any petition or motion in a probate proceeding. And then sub 2 says that a hearing has to be held if there is an objection to the petition or motion that is not withdrawn before the hearing. Does anybody have objections to that language or comments?
That's a good question for Judge Cobb, too.
I was looking at it and I think it looks good to me.
My only question is a drafting one, do you need in its sole discretion? Can we just say the court may require? That's just a drafting question. You don't need to wrestle with it.
Oh, it does say, oh, take out the, yeah, we can take out the sole discretion.
Yeah, that almost seems to be surplus.
Yeah, I left it in because
Yeah.
I have tweaked so much of your language that I didn't want to be too picky. But yeah, I can take that out.
Okay, so section 3 stays in.
All right. So section 4, we've already gone through most of this, but the meeting before last, we talked about changing the definition of interested person to match up with current case law, that since it hasn't gone to the Oregon Supreme Court, it's not completely binding. So the decision was made to update the definition of interested person in statute to match up with that case that I am blanking on the name of at the moment. Matt Whitman, apparently it was his case. So what I did was 19A, so this appears on page 3 of the draft, is interested person means a person having a property right or claim against the estate of a decedent that may be affected by the proceeding. Sub B goes on to explain that interested person includes a decedent's heir, devotee, child, spouse, or creditor if the heir, devotee, child, spouse, or creditor has a property right or claim against the estate. And sub C says that interested person also includes a fiduciary representing a person described in paragraphs A or B. So sub C is written in the way it is. It's slightly different from the current statute to resolve a circular issue that John Draney has pointed out. Sub B is written the way that it is. That's the part that's making it parallel to the current case law, because right now the court held that an heir is not an interested person unless the heir has a property right in the estate. And that, I think, is where the confusion was. So we're clarifying that that's correct. An heir is only an interested person if they have an interest in the estate. Does anybody have comments on that?
I just had this, Jennifer, I just had one grammatical. I think what you did here is fine. My grammatical change is to insert one word where you say property right or claim against. That it makes it sound like it would be property right against the estate. And I think it would be property right in or claim against the estate.
Okay.
And that's in A and B.
Yep.
That works.
All right.
So when we go back to our notice at the commencement of an estate, that's information to heirs, devotees, and interested persons. So heirs do come into that for that notice by virtue of the fact that they are specifically required to be given notice, even though they may not have a property right in the estate. Okay, that works.
Well, they would technically, even if it said in that case interested person, they would, I think that they would still qualify, because there's still a time period during which they could object to things. But once that time period for them filing objections has expired, they no longer have an interest in the estate.
Yeah. Yep, that works.
All right. So are we just going through the outstanding issues right now, or are you wanting to go section by section through this, Lane?
Let's go with outstanding issues as they relate to the sections that we're going through.
Well, I just had one small change in section 6. Again, it's a grammatical.
Oh, wait, section 6?
Yeah.
We're not there yet.
Okay, all right. If you're
So
going
you
to
want to go section by section, and then we'll talk about issues as we're going?
Yeah, as we're going.
Okay. All right, so section 5 is one that we've already settled on the language, but this is talking about the jurisdiction of probate courts. Does anybody have anything they would like to talk about in this section?
No, I think that's good.
All right. Section 6 is talking about, we've added in kind of a laundry list of things that the probate court can do. And so somebody, Jennifer, was it you that had a?
Right. So it's just one word. It's on under 4G, and it's remove a fiduciary whenever that removal is in the best interest of the interested persons. I think it should be of an estate, not for an estate.
Yeah. All right. So again, we've talked about this section previously. Does anybody else have comments or questions about it? Okay. Section 7 is, these are just some small technical changes. I don't think there's anything there we need to talk about. We've gone over this section a couple times.
Well, I just had one kind of big picture question, and that is, how do we know which courts exercise probate jurisdiction? Do we need to have a clear way of knowing that? Does that need to be defined somewhere?
What do you mean?
Well, 2 and 3 talk about, well, all of those sections talk about exercise courts,
Right.
probate court exercising probate jurisdiction, and then circuit court exercising and county court exercising. Do we need to specify which courts those are or anything like that? Or is that's all we have to do, is they are attempting to exercise, anybody can do that, they're attempting to exercise, that means this applies?
That's discussed in 111.075, which we're not amending in this bill.
Okay.
So jurisdiction of all probate matters, causes, and proceedings is vested in the county courts of Gilliam, and there's that whole list.
Right.
And in the circuit court for each other county as provided in 111.115.
Okay, that works then, thanks.
Okay. And then speaking of 111.115, that is our next section. The only change that we've made in this is to add records in sub 3A. So any questions on this section?
Not from me.
All right. Section 9 is amending 111.175, and there is no change in this. So why is it?
Yeah, I was going to say, it's not amending.
I'm wondering. That might be a hanging one, because I had put all of 111 in the draft previously, and then I was taking sections out as we went. So that might be one. Just to confirm, does anybody have any changes they wanted to make to 111.185?
You mean 175?
Yes.
Or 185?
Yeah, both of those. Neither of those have any changes in them. So 175 is the appointment of probate commissioners. And
185 is the duty.
185 is the powers of the probate commissioners. Does anybody want to mess with the probate commissioners at this point?
Oh.
Okay, I'm just gonna take those out then.
Okay.
Section 11
All right.
is amending 205, and this is the pleadings and mode of procedure in probate cases. And I think that we have gone through this a few times. So,
Right. Last time we talked about just what needs to be executed under penalty of perjury, and you've made those changes.
Well, this is Jennifer with, this may be minor and kind of understood, but by deleting motions and objections, that also kind of makes it sound like they don't have to be in writing. So do we want to clarify that motions and objections, even though they don't have to have the perjury aspect, have to be in writing, or is that understood?
Or do you just take out do you just take out in writing? And
Right, that would address the problem.
yeah. I think it's probably a given that a motion is going to have to be in writing, but yeah, maybe that's it, Lori Ann. All petitions, et cetera, must, yeah, all petitions, inventories, reports, and accountings and proceedings for probate court must include a declaration under penalty of perjury.
All right. So are we, I mean, everybody's okay with that? That's not going to cause any issues about the writing requirement? I don't think it should, but
No,
okay.
I'm not going to call Judge Cobb and complain to her and consider that a motion.
Well, again, you could use a comment that just says all of these things are expected to be in writing.
And you know that when I'm thinking about that, when we did the guardianship statute, there's a presumption that all of these things are in writing because remember, we made the oral objection very specific, and there's a whole section, and there was a lot of discussion about, you know, allowing somebody to make an oral objection and how is that put down? Because it seems to me the presumption here, this doesn't make sense if it's not in writing, because if you're making a declaration under oath, you're in my courtroom being, you know, sworn on the record.
Okay. Okay.
Interesting, we're looking up at the language we're striking out of current 111-205. The third sentence is, the proceedings shall be in writing. That's interesting. We certainly don't want to create some sort of a weird presumption that by eliminating that express language in the statute, that somehow we're sanctioning things other than in writing, because now we don't say that.
So should we just add that back in? So the proceedings shall be in writing, and then have that all petitions, inventories, reports, and accountings and proceedings before the probate court must include the declaration?
Yeah, so would you put that language back in sub 1, at the end of sub 1?
So just that one sentence?
Yeah.
So,
It probably can't hurt. At least then we're not taking out that express language about
yeah.
being in writing.
Okay.
Hard to imagine, but yeah, sure. If nobody objects, let's do that, at least for the next draft. Let's put that sentence back in at the end of sub 1.
Okay. So are any objection to moving on to section 12?
Nope.
All right, and so this is the next outstanding issue that I have listed is in this section. So this is amending 111-215, and we have made it through pretty much, I think that we've gone through sub 3E, and that's where we stopped in our last meeting. So that's on the top of the middle of page 9. But before our meeting last time, Jennifer had sent Sandy some proposed language to replace 111-215 sub B on page 8. And this is regarding notice to a minor or financially incapable person. I've incorporated Jennifer's proposed language into the draft, but I think that we need to discuss it. So Lane, you had some comments. So maybe Jennifer, if you could talk about why you want to add this language, and then Lane, you had some comments about it as well.
Well, my main reason for adding this language is to address the ability of making it easy to give notice to minors. And I don't think Lane had any concerns about C. No. And so, you know, I think C would solve the biggest concern that I have. As to B, I agree with what Lane said about the whole issue about how do you determine if somebody's financially incapable? Does it have to be a court determination and all of that? And so maybe the way of doing it is just allowing an agent under a durable power of attorney to appear. But then the question is, how does the PR know about that agent? And so, one way of doing that would be, the agent is able to appear if the agent declares that the agent has authority to act, or some mechanism for the agent to become triggered into the process. But I'm okay with deleting reference to financially incapable because of all of the can of worms that it seems to open.
Is any of this language already covered under the definition of interested person, where we say that interested person includes a fiduciary for an interested person? That would
Well, the conservator would be covered by that.
But an agent under a power of attorney is also a fiduciary.
Well, if we could add that to a comment regarding fiduciary, so that's clear, and that would make it simple. Then it kind of is up to the court to determine how does the agent become involved. And,
right. Yeah, I mean, as we're thinking about this today, that does occur to me. We've said above that a fiduciary for an interested person is also an interested person. So whenever we require notice to an interested person, we're requiring notice to the fiduciary. And I think it's really probably outside the statute when and how a PR or anyone filing a document is going to know that there is a fiduciary. That'll just have to be dealt with as those things come up.
Well, I do want to make sure that we don't somehow trigger responsibility for the PR to know about something.
Right. No, I agree.
Yeah. And so maybe the comment, I don't know if the comment can address that or.
Maybe we just say that if the person filing whatever we're doing here, has knowledge that an interested person, the person entitled to notice, is represented by a fiduciary, then they must serve the fiduciary as well.
Well, so that would be changing back the definition of interested person, where it says includes a fiduciary representing the person.
Right.
And maybe, if the personal representative knows about, or if the moving party or whatever knows about the existence of the fiduciary.
No, because we want to leave that in the definition, because whether or not the PR or the person filing the motion knows that there's a fiduciary, they are still an interested person. Their status is not dependent on the notice of knowledge. What is dependent on knowledge is whether or not a person has to give a fiduciary notice. Because if you don't know that there's a fiduciary, then you're not going to be able to give them notice. But they're still an interested person.
Yeah, I agree.
So in B, are we going to say then just that if a person who is entitled to notice is represented by a fiduciary, then the notice must be given to the fiduciary as well as the person? I mean, that's not the language, but is that what we're going to say? That way, then, this is where it acknowledges that knowledge of that fiduciary is a condition to serving them.
Well, in that case, can we just say that? If the person providing notice reasonably knows that the person to whom notice is being sent has a fiduciary.
Yeah.
So there's an if you know or reasonably know. Okay.
Yeah, I agree.
So then that, notice to a fiduciary also applies under C to a conservator for a minor.
Right.
And a fiduciary, a guardian ad litem, is a guardian ad litem considered a fiduciary? I would think so.
Yeah.
Oh, yeah.
So then you don't even really need to add in C, do you even need to refer to guardian ad litem and conservator?
I don't think so.
Yeah.
Yeah, I think they're covered under B.
Yeah, so then it would just be to both parents and the person if the person is 14 years of age or older. And then both parents is just, of course, if one of them is deceased, then then it's only one. And then that way, we don't have this issue of who's got custody or any of that stuff.
Okay, I'm gonna reorganize that sentence just slightly. So it'll say that it goes to the person if they're 14 or older and to both parents, so that it's clear that or if they're 14 or older doesn't apply to the being to both parents. And so
Yep.
just since that apparently is a thing that's happening right now.
Yeah.
So, okay, so I will make those changes.
Is it understood that parents just means the current relationships that if you've had a termination, that person is not a parent anymore? Is that just understood?
I think.
How is it defined in one? There's a definition it refers to, I think. Oh, minor. That's right, minor. And chapter 107 or something may have a definition.
Yeah.
Right?
I think that's, yeah.
Because under termination, when your parental rights are terminated, you have no, inheritance rights. You have no rights.
Yeah.
So let me ask you: if C, we're changing that simply to say fiduciary, correct?
Yes.
And then if the kid's in state custody, juvenile court kind of thing, that's a fiduciary as well, correct? DHS?
Yeah.
Okay.
I still want to, both parents. Of course, we've always got the issue that one, we may know where one is, but not the other. And I guess we just deal with that as we do with whenever we can't find somebody.
Could we not just say all known parents instead of using a word with a number in it? Or any known parents?
Yeah.
Well, but wait, does that include step parents? And
Parent presumably has a legal definition somewhere. If you can have parental rights, then theoretically you got to be definable.
Parent, so one definition for purposes of child support, parent means the natural or adoptive father or mother of a dependent child or youth offender, a person whose parentage has been established under statute, or a step parent when the person has an obligation to support the dependent child. So it's a little more based on support, but a parent means a parent whose parental rights have not been terminated.
Yeah, maybe, and we don't need a definition. We could probably just tuck that right into this sub paragraph, couldn't we? Because I don't know that we deal with parents otherwise. For the purpose of this section or whatever parent means, a parent whose rights have not been terminated. Might not hurt.
What if the parent's rights have been terminated but then reinstated, which is a thing now in Oregon?
Have been terminated and have not been reinstated.
And okay. All right. Okay, so any other questions or comments on 2B or C?
Wait, just one other awful thing that just came to mind. What if the parent is the slayer?
Wouldn't the Slayer statute things override that?
I'm trying to think. That just means that the parent is not an heir or beneficiary of the estate, but this is different than that. This is really looking at the parent as having a representative role with regard to a child. So maybe we need to add that too, with reference to the Slayer statute.
How about, I mean, if we're going there, how about abuser? So the Slayer statute references abuser as well. So that's a person who's convicted of a felony by reason of conduct that constitutes physical abuse.
But sure, anything that I guess would bring somebody within the Slayer statute, let's kick them out for these purposes as well.
So is the PR doing all the research to figure this out? What if they
We're talking about Slayer statute, your PR usually knows. That's frequently part of why they're there.
Yeah. And I think there has to have been a determination.
Well, and the Slayer statute is so rare. And if this becomes an issue, the PR could file a motion with the court to determine whether notice is required. You know, I mean, that is so rare.
Okay.
We don't want notice to be required. I would really appreciate we say that explicitly, because I've been in multiple jurisdictions where if we don't explicitly say in statute that notice is not meant to be required, we will be required to give notice, even if that notice is going to have no practical meaning or effect.
All right. Yeah, Lorianne, let's just give it a try for the next draft and refer to, you know, somebody who's been found to, determined to be under the Slayer statute.
Or maybe I can just reference to the Slayer statute.
Yeah.
So a parent, if they would be under this, then they're not a parent for purposes of notice.
Well, I think there has to be a determination of that though, because the PR, can't just do that on the basis of their belief or suspicion.
Yeah.
Realistically, a lot of times when this comes up, we've got, for example, husband kills wife. There's an immediate estate because there's the, 3 young kids, et cetera,
Right.
et cetera. There's no determination because he's still in jail waiting to be tried on the case. And, he's going to have notice of it. He's going to file lots of pro se things. I don't know that the burden is going to be on the personal representative to find out all this stuff.
And if the personal representative sends notice to a parent and they shouldn't have, is there any problem with that?
No.
Not that I've ever seen. I mean, it's just it's additional pleading saying we don't want to let, Mr. Crazy Killer file any more pleadings in this or something like that, so you can kind of move the estate forward.
It just depends on what kind of location information ends up in whatever pleading we're requiring notice of, because we probably don't want to accidentally tell the crazy killer person where their children are so they can go kill more of them. And I've had, not with killing related concerns.
Right, but abuse.
I have had cases where one of the parties that would be entitled to notice is a party that we have abuse concerns related to, and some of the information that might be contained in the notice would provide location information of a suspected victim.
Maybe here what we could say is both parents, unless the court for good cause determines that that notice is not required. And there we just leave it up to the person giving notice. If they've got reason to believe that they should not have to give notice, they ask the court.
I think that's a good approach. That's just simpler. And it's going to be rare that this comes up.
It is going to be rare.
And in those circumstances, when it does come up, the personal representative is going to know.
Yeah. Want to try that, Lorianne?
Yeah. All right.
Okay.
So just to rephrase what I think I heard you say, so it's going to be that notice must be given to both parents unless the court determines for good cause not to. I'll tweak
Yeah.
it. But that's
Yeah.
what you're going with, right?
Yeah. And then do you still want to add the sentences for the purpose of this section that parent does not include a parent whose rights have been terminated, have not been reinstated?
Yeah.
Okay. Let's try that. Not sure it's final yet, but I think it's a step forward.
Okay.
All right.
So any more comments on B or C? All right. So my next comment had to do with actually sub D. So in this paragraph, we're saying that if the address of any person can't be determined, that with reasonable diligence, that the person giving notice has to notify the court that they weren't able to find them. My question is how this relates to subsections 3, E, and F.
Yeah, that was my question.
Next page.
So this is Jennifer, and I would suggest that we just add that the notice proposed an alternate method of service or something, so the court has some action that it can take to deal with this.
Well, let's look at E and F, 3E and F, because that deals with the same scenario where you don't know.
So 3E is if the address of a person's not known or can't be ascertained with reasonable diligence, then you give notice by publishing a copy of the notice.
Right.
And that's the whole publication of notice. 3 says that upon good cause shown, any other method determined by the court to be reasonably suitable under the circumstances.
Yeah, with those two, I'm not sure we need 2D. They seem to address the same circumstance, but differently.
Yeah.
And F gives you that opening, Jennifer, to come up with a different method of service.
Okay, but what this does is it makes it clear that you can't just not give notice to someone because you can't find them, which...
Well, don't E and F say that? 3E and F? Because 3E says if you can't find them, you publish, and F says, or, you serve by another method.
Okay,
So I don't
you're
think,
right. That may do it.
yeah. Yeah, I don't see those as excusing some form of effort to give notice. So I think we take out 2D.
I agree. Unless there's a policy purpose for keeping it in there. Okay.
I don't think so. I think it's covered.
All right. So moving on, where we stopped last time, we got done talking about 3E. So let's talk about 3D. So another way is to give notices upon good cause shown, any other method determined by the court to be reasonably suitable under the circumstances and likely to result in receipt of notice. So in our last meeting, we talked about why we should keep the publication of notice in there with respect to some due process concerns. And 3F kind of adds a little bit of an escape valve that if the court thinks that there's a better way to give notice, that you can do that. So you might not have to publish.
Yeah.
Anybody have questions or comments about sub 3F?
I think 3F, we want to leave that in if we're taking out 2D.
Okay.
So what would that be? Maybe this person's on Facebook. So you post it to their Facebook.
Oh my gosh.
But also room for email.
Yeah.
I mean, I've had that come up multiple times recently. We have no idea where this beneficiary lives, and the only people that ever talk to them only have an email. And for some reason or another, they're paranoid about the existence of attorneys and do not, under any circumstances, want to release a notice address so we can just send them mail and never hear from them again.
Yeah. Yeah, I guess if you can persuade the court that that's reasonably calculated that meets the due process requirement, then yeah. I like this because we're just expanding the opportunity to satisfy due process. And you may have something better than publication.
Would it work to also mention, one of the things below F is a crossed out sub 2, and that says the court may authorize notice by electronic means under this subsection. Would that be okay to include?
Well, we address electronic notice up in sub C. So if the person consents in writing.
Okay, but what happens if they don't consent in writing and that's the only way to reach them?
Right. I would leave that. I would leave that in. That would be sort of a non-consensual electronic notice. If you know and can persuade the court that there is an address that this person uses on a daily basis, they haven't consented, but we know it's good. I would think the court could say, yeah, go ahead and authorize, go ahead and serve.
So what if I just tacked that on to the end of sub F?
Yeah.
So it would be like comma, including notice by electronic means.
Okay. Yeah, I like that.
All right. I might need to do a notwithstanding to clarify that sub C and sub F work together. I'll look into that.
Yeah, that's a good point. So under C, it's a preferred
maybe
method.
Accept.
Under C, it's a preferred method if the person has consented. Under F, it's an authorized method, even if they haven't consented.
So I might add to sub C, except as otherwise ordered by the court.
Yeah. Okay. Well, I'm not sure if that works.
Because sub C it's triggered by consent to the electronic.
Right. I'd almost think notwithstanding works better in F than except as provided in C. But yeah, you can work that out.
Okay. All right. So we've taken out sub 2, the existing sub 2, and pretty much incorporated that into the new sub 2.
Right.
And sub 3 is except as otherwise ordered by the court or specifically provided in the probate code. The notice described in subsection 1 of this section must be given no later than 15 days before the earlier of the date for filing objections to the petition or other pleading or the date set for hearing. Any issues with that? So sub 4, there are just a couple of technical fixes. The prior sub 4 that we're taking out entirely, that got incorporated into 2C. And then I've added in, at the request of the group, sub 5 that says the time within which to act is to be done under the probate code is determined under ORS 174, 120, and 174, 125. That's a cross-reference to the statutes about statutory construction in Oregon. Those already apply, but there was a concern that perhaps practitioners wouldn't know to look under 174 for how to construe statutes. So although we don't normally do it, I did throw in that little breadcrumb. Does anybody have questions or comments about that? Okay. Moving on, section 13 This is amending 111-218, which is proof of service.
Yeah.
And so we're saying that proof of service must be made for all documents that require notice. And if notice of a document is not required, no proof of service is required. That was language the group provided. I think there was some concern that if we don't restate that, people might be confused. I don't necessarily think it's necessary, but if that's the group's preference, I'm not going to make an issue about it. Does anybody have comments on that? Leave it as is.
Yeah, I'm fine with that.
I like to leave it as is, just because, you know, one of the things that we have to be able to do if the court asks us to do something that is odd is be able to say, well, here's why we don't have to do that. And that happens sometimes.
Okay. Proof of service of a document may be on the document filed in the form of a proof of service of a document may be on the document filed in the form of a certificate. Oh, I see. Certificate of service attached to the document. So, or it may be in a separate filing.
Yep.
Okay. So that is, I think I went the wrong way. Sorry, I just got lost.
We are at section
13? We just finished 13? Okay. So section 14 is amending 111-235. This is objections. So an interested person or the PR may file a written objection to a petition or motion. The objection must include a plain and concise statement of the basis for the objection, be served on the persons described in section 8. Check that cross-reference. And be filed on or before the earlier of the final date for the filing of objections to the petition or motion or the date of the hearing. No objections, if no objections are filed before the final date for filing objections to the petition or motion, or if all filed objections are withdrawn, the court may sign the proposed order or judgment without further notice to any person. Does anybody have comments on that? That I think is language that was provided to me, so.
That all works for me. I just want to make sure that the lawyers get notice of an objection. So the objection is filed with the court. Shouldn't that party also have to file it with the lawyers or the parties?
well, that's in the person's described in section 8.
Oh, okay.
Yeah, and that
Oh, there we go.
cross-reference is not good.
Right, that'll be a different number now.
Yeah,
But yeah, that does include lawyers if the person is represented or has given notice that they want a lawyer to be served, right? So I think that's covered.
I'll
On
make sure.
sorry, on sub C or the date of the hearing, does that mean it has to be filed on or before the earlier of the final date for the filing of objections to the petition or motion or the date of the hearing?
Yeah.
So what's the, or the date of the hearing? Give me a scenario that your objection to the date, on the date of the hearing.
Why are you having a hearing if the objection hasn't already been filed?
Right.
Well, we can have multiple objecting parties.
Right.
So does that mean Johnny come lately can file something the day before the hearing?
That I don't know, but that's the only way I could come up with somebody else objecting.
Right. I was going there too, but that's a good question, Judge. I'm not sure that we want to encourage that.
Because can you imagine the two attorneys, the objector and the attorney for the PR, have gotten, you know, all the issues nailed down, all the pleadings filed. We've got a 5-day hearing, and then we've got 3, you know, pro se's filing objections the day before the hearing?
Well, except this says, and this, I think it's still a good question, but it says they have to be filed on the earlier of. So if there's a date for filing objections and that date is passed, then you can't show up at the hearing with your new objections. So in what case would the hearing be, the question really is, in what scenario would the hearing be before the date for filing objections?
I mean, if this was applying to 125, I'd say we have lots of situations where we have an open objection period and we're doing a hearing on a temporary petition.
Oh, sure.
But I don't remember if 111 applies to 125.
Mm-mm.
It doesn't.
So,
This language just seems to be confusing to me about, or the date of the hearing.
Yeah, the question really is, when would you have a hearing before the date for filing objections has passed?
Right.
So maybe we don't need the date of the hearing. I'm not sure where that came from.
Well, so would it be a situation where the proponent just simply requests a hearing? They know the judge is going to want to have a hearing and they don't even file a notice of time for filing objections. They just request a hearing.
Why?
Notice in that case.
Then they would give notice of the hearing.
But why? Okay, then you show up at the hearing, right?
Right.
And then the judge is looking at you saying, Ms. Todd, what is this about? Why did this get set on your docket?
All right. Well, so because, you know, that was the old statute and that was part of the problem, is it always was about setting a hearing, which we never did. And so we were like, no, we just want to be able to give notice. And so maybe we just eliminate that as an option. And then all we have is it ties to the timing of the filing of the objection or the, yeah.
All right. So I'm going to change that to the objections must be filed on or before the final date for the filing of objections to the petition or motion.
Yeah, yeah.
Well, and I think that also relates back to something that we had before that referred to the hearing or the objection or the timing of that.
I think that had to do with whether you had to hold a hearing.
Right.
So
Okay.
if the objections had been withdrawn before the date for the hearing, that you didn't have to have the hearing.
Yeah, yeah. Yeah, I think we just take out that or the date of the hearing and take out the earlier of.
Okay.
Good. Good catch.
Any other comments on section 14? All right. Section 15 is amending 111-245, which is proof of documents in probate. So
This is Jennifer, and I was just wondering, do any other jurisdictions still have decrees that we would want to mention, order, decree, or judgment? Are there any other ways that other courts exercise their authority?
Other states do have decrees.
Or rather than trying to guess what all the court documents might be called, we could say just a sort of a copy of the order, judgment, or other document admitting the will to probate, something like that. But I'm guessing if you showed up with a document that admits a will to probate filed in Connecticut and it's called the decree, I don't think anyone would have, I don't think the court would have any basis to not accept that. It's functionally the same, right?
Right, it's functionally the same. I just don't know, if a litigator is going to come along and say, well, wait a second, it's not an order of judgment. I mean, that seems kind of frivolous, but I don't know. That's just something I noticed. It's not a big deal.
What if we change it to a certified copy of the court document admitting the will to probate? All right.
Yeah, and then, just checking to see. Susan, maybe just a comment that, that document is intended, the reference to document is intended to encompass the waterfront of things the courts assign, whatever they're called.
Well, and the same issue arises under subsection 2 below.
Yep. Oh, so under sub 2, okay.
And maybe the
No,
way.
actually, I think 2 actually it solves itself, because you say a document filed or entered in a foreign jurisdiction. So there we've already kind of given that broad reference to whatever it might be.
Right, so we could just delete order or judgment and just say, hey,
Oh, I
document
see what you mean.
file.
Okay. Yeah, probably could. That's right. Yeah, because we would say a document filed, which would be something that a petitioner might file, or entered, which would be something that a court would do. So yeah, I think that's right. We can probably do without order or judgment in that entire section.
Okay.
Okay.
Any other comments to section 15? Okay. Section 16 is amending chapter 111-255. And this is just about translations. I think it's mostly just a technical fix.
Yeah.
Any comments to that? Okay. Section 17 is amending 111-275. This is on judgments and what judgments look like, limited judgments. So there's a laundry list of things that have folks looked at this list of things that require that limited judgments apply to? So do we need to go through that?
So this is just saying these things are not determined by general judgments. Is that what we're saying?
I think that it's saying that limited judgments can only be used for these things.
Yeah, well, right.
But it uses the word may, so you could address these in a general judgment.
No, I think this is the case where may means shall, isn't it, Lorianne? We have only.
So the court in a probate proceeding may enter a limited judgment only for the following decisions of the court.
And we don't want to say shall because we may not want the court to enter a limited judgment.
So we're saying that if the court's going to enter a limited judgment, these are the things that can be in the limited judgment.
Right.
So I think the question about whether these things can be in a general judgment, I think they can be. It's not, it doesn't limit how you can use a general judgment. It limits how you use limited judgment. Does that make sense? That's my understanding of it. If that's not the way it should be written, then tell me what you want how you want it to be, and I will change how it is worded.
I think it should be written that way. And the example that you could have is it could be that There's a petition for elective share has been, invalidated or not followed up on or withdrawn or whatever. And the general judgment could say, and it just hasn't been addressed, the general judgment could say the elective share has been withdrawn or whatever.
That is interesting. You can read that two ways. The court may enter a limited judgment, only, which is where may means shall, or may enter a limited judgment only for the following decisions of the court. Funny, that's never been ambiguous before.
Well, I think only if you were trying to make it a shall, the only would be before the entry of.
Yeah, okay, I think you're right.
Only enter a limited judgment for the following decision.
Right. I think you're right. No, that's fine. Like I say, it's never been an issue, so I don't think adding to the laundry list is going to make it an issue.
Just a typo under sub K. Any other decision that's a final determination of the rights, that should be not or, but of.
Ooh. I bet that's one of the most common typos.
Well, and on that same section, do we want to say parties or do we want to say interested persons? I don't really know. That just caught my eye.
Mm. Or just persons. Well, yeah.
Well, I mean, is a personal representative considered, would there ever be a decision that's a final determination on the rights of a PR? Because they aren't necessarily an interested person, are they?
Well, surcharge, yeah, fees. I don't know. It sort of think it seems to me like you could have an interested party whose rights are being affected, who may not have technically been a party, and it just seems like you might want to include it that way. And then maybe you need to say interested parties or the personal representative to cover that.
Or why not just persons?
I think persons works.
Well, what if the bank is a PR? Then that
person
bank's a person.
Person
Okay.
includes corporations.
Okay.
Yeah.
Well, then that works. That would be better from my perspective.
Okay, that's a good point. Because we generally don't use the term parties. Yeah.
All right, so were we wanting to add that these things could be decided in a general judgment to really call that out, or are we good with the way that the lead in to sub 1 is written?
I think unless anyone's had a problem with it, because again, we're not amending that aspect of this statute. So unless that seems to be a problem anywhere, I'm not sure we need to do anything with it.
All right, I'm gonna leave it as is, not hearing any comments to that. So section 18 is,
Wait a minute, before we move on, can I
Yep.
throw in a couple
Yep,
wording
please.
questions here? In I, and any surety should be or surety. The and is kind of the wrong word there, because you could surcharge one and not the other. I think it would make more sense if it said a decision on surcharge of a fiduciary or a surety.
did you have another comment, John? I thought you said you had a couple.
I don't like E. A decision on elective share makes it just sounds to me like we're not lawyers. There should be more words in there.
decision on a petition for elective share or what?
Something, yeah, I mean, I just, it seems like a shorthand to me. There's no, it lacks precision.
Is it a petition for elective share or is it a motion?
Find out.
Petition?
Well, and the other thing that could come up is the judge could, on his or her own motion, raise the issue of elective share and require a time to pass or something. I don't know.
Really? Do you think a judge would do that?
Not me, man.
Yeah.
Yeah.
I don't think so.
Hey, is it even an elective share anymore?
Yeah,
I don't know, what's the statute say?
it's, what is it? Is it 114?
Yeah, I had it come up recently, and I had to do all the calculations and the augmented estate and the whole thing.
Right.
And actually, one time when I was reviewing an order in a probate estate where the entire estate was, the spouse was getting nothing, and there was a 1-year period in which the spouse can request elective share. I required either consent from the spouse or the passage of that time because you're cutting off the right of the spouse then.
Yeah, we definitely have elective share. That was a project of the Law Commission.
Yeah, but is that what it's called?
Huh?
Is that what it's actually called?
Yes.
Is that what it's actually called?
Yes.
I remember. Okay.
It's
Yeah, so I
114,
guess, Lorianne,
600.
Just check the statute and see whether it's a motion or petition.
Yeah, I'm not sure. It says it's you make an election, right? So you make a claim. Oh, it is a petition or a motion.
There you go.
So we
Yeah.
it
So
to
John, you get the waterfront, a decision on a petition or motion for elective share.
all right.
Just a question. It kind of came up before, it's because it just kind of follows on the heels of elective share. Should a petition or motion for support be on this list?
Well, it probably should, because that might be an issue that the spouse would want to appeal.
Yeah.
Because it could be, depending on the situation, it could be a significant amount of money.
I would add.
Would that be under any other decision that's the final determination of rights?
I think you could just say a petition or motion for support or elective share. And then that way, those two issues that are possible are called out, and then
Okay.
there are other things.
Yeah, Judge Cobb, I guess the reason I hesitated in your question, I'm not sure, support seems to me to be sort of an interlocutory kind of remedy, and I'm, maybe it's, I don't know. If we can do that though, decision on support or petition or motion for support or elective share. Does that work for you, Lorianne?
Mm-hmm.
Okay. All right. We're doing well. Keep going.
All right. So section 18. I think
18 and 19, I don't see any changes in those.
yeah, I think these were just included for conversation when we were
We've
talking
had plenty of that.
about defining what a probate proceeding was, maybe.
Well, it's more fundamental to me of, do we even need either one of those sections? I mean, probate, the process now with the Odyssey is we don't keep those records separate from other records and proceedings. And, you know, it's talking about a register and a probate index. We don't do those things, I don't think. We do have a register.
We did our probate clerks here. Jeff or
Right.
Judge Cobb, do you know, do these things exist anymore?
Well, juvenile matters do, right?
Well, and there
What-
is a reason why I suppose you could keep juvenile matters separate because they're confidential, but why would they keep probate records separate? And we don't do that.
Well,
Let's-
I'm wondering
Oh,
this
wait.
runs amok of, for example, like all the numbering systems in the courts identify probate records as opposed to civil records. So do you want to, if you eliminate this, is that going to cause the courts to go, oh my God, we're going to call all probate
Yeah.
civil?
I think that 18 and 19 are both a question for the court, whether they still serve any function. And if they do, leave it in. I don't think it doesn't affect practitioners at all.
I agree with what Judge Cobb just said about section 18, but section 19, I still don't know about this index and register and all that stuff. So
Sandy, let's touch base with Jeff and who's
Okay.
our other, Brian, is he still following us?
He's come a couple times, but Jeff's been the most consistent.
Yeah, let's check with them because to me, this really is all about court business.
Okay.
It's
I'll
in the
check.
law right now.
This is Rita. I'll check with some of the folks that
Okay.
I know that, kind of on the ground to see if this is a kerfuffle.
All right. I'll send a note to Jeff as well.
Okay, so yeah, let's leave these in just to make sure we don't lose track of them. But then maybe by next week we'll know.
Lane, what's already in the law?
What's that? What's already in?
Yeah, what's already in the law? Aren't we adding
Just what we're
these
looking
things
at
here?
there. Section 18 and section 19 are both existing current statutes. So really the question is, do we amend them or take them out? And I don't know how
Well, we're-
important they are to the courts.
Are we amending them?
No,
I don't
not,
see an
not
amendment.
now.
Okay.
Yeah, so unless the courts, I think unless the courts want something done with these, I would probably just be inclined to take them out of this bill, but let's leave them in for now so we don't lose track of the question.
All right, so moving on, section 20 is amending 113, 125. And so this is to do with the letters of administration or testamentary. It's added in a new sub 2 that says that the letters testamentary or of appointment must reflect any conditions or limitations imposed by the court on the fiduciary.
this is Jennifer, and I think that's fine. I had one small change if no one has anything else. At the very bottom of page 11, where we're talking about letters testamentary, it talks about personal representatives with the will annexed. And that is so archaic. Can we just leave that out? And then in the next page, it talks about your acting personal representative of the will and estate. And of course, you're the PR of the estate, but are you the PR of the will?
It doesn't, again, that doesn't affect us as practitioners. Seems archaic. Judge Cobb, do you know?
I don't.
And it's the wording of the letters testamentary, or it's supposed to be.
Right.
Yeah.
Also, we want to make it look like whatever a bank is expecting it to look like.
Yeah, but the banks probably don't read. All they're looking for is the court
They're
seal.
looking for that purple stamp.
And I'm wondering if the language is for the third parties of the world. It's the personal representative of the will.
Yeah, I'm not inclined to spend a lot of time on it. It's never caused a problem.
Well, we are trying to modernize, but
That's true.
it's not a big deal.
Yeah.
It's not a big deal.
If we run
Well,
out of
Lane,
time,
can
if we run out of time and things to talk about, we can come back to it.
Lane, can I
Yeah, John.
go back to 2?
Oh, yeah.
Why do we use letters of appointment? There's no such thing.
Oh, you're right. Letters of administration.
Yes.
What? I missed that completely. That's right.
Somebody just read that and said that.
I did.
I heard administration.
It's possible I
We all
said
did.
administration because I thought mentally.
No, you said appointment.
Okay.
No, you said appointment.
That's a good catch. Yep, that's administration.
All right. So are we leaving the text in the letters itself about
For
that?
now, yeah. I'd say
That's, we're just not
we
touching
got,
that.
yeah, we've got other things probably
Okay.
to talk about that are more important.
All right. So moving on to section 21. This is amending ORS 113, 145. This is the next section that I had a question on. So this is talking about sending out the notice to heirs and devotees and also providing the notice to DHS and OHA. It's OHA, right? Yeah. So there was a comment in the initial language that was provided that's said that the certificate of service or the declaration regarding providing note information to heirs and devotees and the death record to DHS, that provision isn't sufficient, that we need something more. And I'm not sure I understand what more we need, because if you look at on page 13 sub 4, that's the part that requires, that's the requirement to send in the proof of delivery of mailing the notice. And so it's mailing required by this section. And this section includes both the notice to heirs and devotees and the notice to DHS and OHA. So if there's some concern that maybe that could be interpreted to only mean the notice to the heirs and devotees, do you want to call out subsections 1 or 6? But then there could be a question about whether you have to provide certificate or no. I mean, what is it that you're looking for in it?
Who was speaking up for that?
That I think that was in the initial language that Jennifer and Heather provided.
You know, and I can't remember what the concern was on that. It's been so long, and Heather, it looks like, had to leave. So, you know what? Let me ask.
Jennifer, I'm still here.
Oh, okay. Sorry, I just didn't see you on my screen. So, can you remember what this is about, Heather?
No, so I'm so sorry.
Yeah.
My brain is just like, I'm not sure I could rent it out to clients any longer.
I think it's not a concern I have anymore. So if you want to just eliminate that take that whole section out, I'm good with that.
All right. And we're still okay. We're not messing with the notice to DHS or OHA, or
No,
as otherwise provided in rule.
No, I think we're good on that.
All right. So section 22 is amending 114 to 25. And so this is a cross-reference to the new provision that specifically grants the probate court authority to order delivery of property. And
right.
So there's
Yeah, this has been the topic of conversation on the listserv recently.
I think this language may have come from, well, I know it was in the initial draft language that was provided by the group, and I haven't really tweaked it, so you might want to look at it.
Yeah, so here we are. If a PR is filing a motion for delivery of possession, so now you've got an heir or a third party, doesn't matter, in the house. So you're filing under 111.095 for possession. You need to say why Chapter 90 doesn't apply, because if Chapter 90 does apply, then the PR has to go through the Chapter 90 FED kind of a proceeding to get custody. Is that what this is saying?
Yeah, I think so.
Yeah, and that makes sense.
Well, yeah, that was the intent on this because if ORS Chapter 90 applies, then you have a process. The problem
Right.
is it usually doesn't apply, and then you
Right.
don't have a process, and you have the whole court proceeding.
So then you say, okay, ORS 90 doesn't apply because they're not a tenant under the act. So then you give notice of the motion to all adult occupants whose names can be determined, reasonable effort, okay. And attach written notice in a secure manner.
And the kind of the intent on the written notice was that was the process used in the FED
Sure.
statutes for notice.
Yeah. I think as a matter of procedure, that works. And the manner by which you give notice is all governed by the other statute, 111-215. Okay,
So we're good
I
with
think we're
this?
good, Lori. Lorianne?
Okay, we might make it through.
Yeah, we might. This is a first.
So section 23 is amending ORS 114-275. So we're just saying, we're cross-referencing back to, again, the changes that we're making to 111-095 that calls out that list of what the probate court has authority to do. I'm wondering if we should be more specific. Right now, it just says relief pursuant to ORS 111-095. Does anybody have an objection to changing that to 095 sub 4? So it's really clear what we're
Okay,
point to.
no, that makes sense.
Okay, section 24 is another one that I had a question on. So
We just changed this last time around, so what?
what?
Oh, with this, we just changed the statute the
Oh.
last time we went through.
Okay,
Wait, this is Jennifer with one question about section 23. I just want to make sure somewhere it's clear that we have the authority to petition for instructions.
yes.
Okay.
Well, isn't that in 095? The new 095, which is,
Well, I don't think it talks about petition for instructions.
Let's see.
And that really is more of a process, you know, the idea of petition for instructions, that's not a remedy.
so should we say may apply to the court for instructions or relief?
Yeah, that works.
Or do we add instructions to 0954? That might make more sense.
It should be in 095.
Yeah, let's do that, Lorianne.
Yeah, that's better.
So what would it, court having jurisdiction over a probate proceeding may do what? Issue instructions, provide
Yeah.
instructions? How, what do you
Yeah.
say?
I mean, you got it in J. It's already, you already got instructions in J.
Well, let's see. Oh, okay. Or the
Ah,
court.
there you go.
Okay,
Okay.
yep, you're right. There it is.
Good, good, okay.
All right, so we're
Look
good.
at how good we did.
Yeah. We just forgot how
Even
good.
when you did, even though you didn't know it, yeah.
All right. Lost my place again. We're on the
No,
wrong-
to me, that's a sign that we're starting to close the gaps on this when we're thinking we need to do something and found out we've already done it. That's good.
Okay, so section 24 is amending, well, there's no amendment in it right now, but it's,
What was your question about it, Lorianne?
so 114.395, there was a comment in the language the group provided that says that 114.395 was enacted in 1969 and may not incorporate 130.815, which was enacted in 2005. So 138.15 says that attorney fees and costs. So in a judicial proceeding involving the validity or administration of a trust, the court may award costs and expenses and reasonable attorney fees to any party to be paid by another party or from the trust. So my question is, what does the group want to incorporate into 114.395 from 138.15?
Huh, I thought we were.
Explained in the language that was provided.
That's a big subject. As it stands, 138.15 is very, very seldom applied. But, there's certainly a case to be made for including it in the probate code. Although some people would think that would be un-American and violate their rights to complain about everything.
We're down to about 8 minutes. Let's just kind of hold that, I think, and maybe yeah, Lorianne, one more time, what the thinking was of incorporating from 130.
So what was provided to me was just a comment that said that 114.395 was enacted in 1969 and did not incorporate 138.15, which was enacted in 2005. That's all. I don't.
Okay. Sandy, don't do anything about it in the next one for our next meeting next week. Send out, include that statute from 130 in our meeting material so we can take a look at that.
Okay.
It was included. Just saying.
Where?
In my notes about the outstanding questions.
Oh, I missed that. Okay.
I will make sure the
Never
notes
mind.
that Lorianne put together are sent out again.
Okay, so let's do that one next time. Section 25, the group approved the language that's in this on August 12th. So if y'all don't mind, I kind of want to try to get to section 26.
Go ahead.
So there were no changes to section 26 in the language that was provided, but subsection 2C references ORCP 68. And I'm curious how the group wants to deal with this. So we've already said that ORCP 68 doesn't apply to probate proceedings. It applies if there's a contested issue in probate proceedings though. So in this section, it says that an award of reasonable attorney fees, that ORCP 68 does not apply to the request for attorney fees under this section. So how is this still relevant since we've said that 68 doesn't apply in probate proceedings? Are you is it just a hanging reference that we need to delete? Or are you wanting to say that ORCP 68 doesn't apply in contested proceedings? And if that's the case, then can we go take it out of section 2 that says that 68 applies?
No, I think 68 does apply in a contested proceeding.
So my inclination is to take this out of this section. I think that it's just a hanging reference that was overlooked.
Maybe as long as we have a comment that by taking it out, we're not implying that it does apply.
This is Jennifer, and it might be good to ask Matt Whitman that question, because I think he was involved with this attorney fee language. Is that right, Heather?
But this is your attorney fee that you go in at the end of the estate, right?
Right.
Yeah. So, yeah.
I think if we ask Matt Whitman and Brooks and the other Matt Schrum, then they would be the ones who would know this.
I think the goal was, when we added this, is that it's never clear when, 68 does not apply in estates. It can't even apply in a contested proceeding in an estate, because you don't get attorney fees in estates unless it's an ORS 20 kind of misbehavior issue.
Oh, it could be an action. It could be an action within the estate on a claim, on a contract.
So we have said in section 2(3)(b), we've said that ORCP 68 does apply to a contested issue in a probate proceeding.
Right. And Otherwise, it doesn't apply. Yeah, so Lorianne, I think we probably can take that I think we can take it out
Okay.
of 116, 183. And again, a comment just to say the reason we're taking it out is because it's already addressed in section 2 of this bill, that it does not apply except in the case of a contested proceeding.
Okay.
So if you get to the end of the estate and you file your affidavit of attorney fees along with the final accounting and there's no contest, then you don't need to comply with 68. Yeah.
Okay. So that is pretty much the end of my questions. Matt Whitman had raised an issue about filing fees, and I think it would be helpful if we talk that through with him. So I guess what he said was, as we work to integrate ordinary civil litigation procedures into probate contested cases, we'll need to make sure to change the related statutes. For example, we'll need people filing summary judgment motions to pay the standard $111 motion filing fee, so that that requires a change to ORS 21-200. Currently, the statute does not include probate cases for which the filing fee is due under 21-170. As cases for which a summary judgment motion filing fee is required. So my question was, what other fees are we needing to update? I can go in and update 21-200, but folks who are out there in the world seeing how this stuff works in real time, if you could let me know what other fees we should look at as amending.
That would be a good question for the courts as well, because I'm sure they'd have an opinion about that.
Okay,
This
so
is Rita. I'll run. Okay, I know.
I took a note
Say,
to talk
Lane.
to the courts. Yeah.
Okay.
Lane, could I take us back to section 12 real quick?
Whoa.
You guys
Okay.
probably-
Yeah, you got 2 minutes.
I was gone when you guys addressed that. You probably got these, but I had two quick little points
Must
to
be
bring up.
present to win, John.
In 2B, the reference to a durable power of attorney is a reference to
we've
something.
rewritten that completely.
Okay, and the power that allows the management of all the person's financial affairs.
All that language is gone. It's just going to refer to a fiduciary.
Okay, all right, that was all I had.
Okay. Hey, good job, everybody. Lorianne, we even whittled down made progress on your questions.
yes.
Great. Well, we've
So-
got a couple things to ask the courts about to make
Yep.
sure that we allow them some input on things that are going to be important to them. We've got a little bit of redrafting, not a whole lot of redrafting. Let's look at this again next Friday.
Next Friday, hopefully we can get done.
And then we'll get to e-wills.
Yes.
All right.
All right. Thank you
Okay.
all.
Good meeting. Thanks, everybody.
Thanks.
Take care.
Bye.